Let me introduce myself. My name is George Gould. I'm an attorney, the managing attorney for the housing and energy units in Philadelphia. And with me is David Ramler, who is an attorney, the legislative director?
Director of Government
Relations for the National Housing Law Project. And David is in Washington, D.C., and David was kind enough to come here today to talk about this important topic. And the topic we're going to talk about is hopefully something that you are aware of. There have been emails going out about it. It's a law that became effective and passed on May 20th, 2009, protecting tenants at foreclosure. And the name of the act speaks for itself. It deals with the problem of what happens to tenants when their landlords are foreclosed. And what we want to do in the brief period of time we have today is to talk obviously about the law, but also to talk about what the law was before, because we suspect that there are going to be some banks and others who purchase at sheriff sales who are not aware of the new law. And there's some questions out there as to whether or not really you want your clients to be part of the new law, or do you want them really to be considered just occupants and not really to be considered tenants? Let me back up a little bit before May 20th and talk about, and there is I'm not going to spend a lot of time on this, but we put together a memo which is part of your materials. It should be part of your materials, which talks about Pennsylvania law prior to the passage of protecting tenants at foreclosure. One of the other things that's important, at least at the moment, this law expires at the end of December 2012. So it's a limited time period, although obviously there's going to be an effort, we hope, to get the law extended. Prior to May 20th, the law in Pennsylvania was somewhat simple as to what happens to a tenant in a foreclosure situation. If the tenant entered into a lease that preceded the recording of the mortgage that was eventually foreclosed, whoever purchased it at the sheriff's sale takes the property subject to that lease. If it does not precede the recording of the mortgage and is afterwards, the lease is extinguished by the sheriff's sale, and unless the purchaser at the property takes some affirmative act, and this is in the memo, to continue the lease, the occupant or the former tenant is no longer a tenant and is basically an occupant. That's obviously bad. However, in Pennsylvania, the law is, I believe, very clear that the purchaser, and again we're talking prior to May 20th, the purchaser at the sheriff's sale is required to go in the court and to take action against the occupant to get them out of the property. In Pennsylvania, they cannot go in to basically landlord-tenant court because the person is not a tenant. And that often happens, and we have in the past gone in and argued the person is not a tenant, and they have to go to common pleas court, which basically means they have to file either an ejectment or quiet title action. In 99% of the cases, it's an ejectment action. In Philadelphia, the ejectment action, it has to be, one, the deed has to transfer to the purchaser at sale, and then they have to go to court and they have to file the action. They have to wait the 20 days, get a default judgment, send a notice of an intent to take a default, and then they have to get a writ of possession, and they have to go through the process of getting the occupant evicted. That takes, realistically, in Philadelphia, probably 2.5 months, maybe a little more, maybe a little less. If the purchaser is really streamlined, maybe they can do it quicker. But it does take some time, and we have generally seen that most purchasers at sale go through that process. If it's an individual, sometimes they just try to force the person out, and that can be stopped. It's pretty rare, although it happens, that prior to May 20th, that purchasers at sale were willing to enter into any kind of a lease arrangement, even though we think it's against their interest and it would make sense to keep a property occupied. Unless the property had more than 4 units, it was generally our experience that the purchaser at sale wanted the people out. Sometimes they would give them what was called cash for keys, which they also would give to homeowners who remain in the property because the ejectment process is the same. And that would range anywhere between $500, $1,000, maybe even $1,500. But the real problem for the tenant, which Dave will talk about, is when they're in that situation and they have to pick up and leave, they need to get moving expenses, and then they need to get a security deposit for a new place, which can often be 2 months' rent and the first month rent. So we're talking about 3 months' rent and moving expenses, which obviously for our clients is very difficult. Sometimes our clients knew that there was a sheriff's sale simply because the mail would come to the property, and they would open it. Sometimes they didn't open it. Sometimes they didn't know. Depends on their relationship to the landlord, but we come across all different situations. Things have changed pretty dramatically, and on May 20th, the Protecting Tenants at Foreclosure Act became law. So why doesn't David pick it up from here to sort of go over what's in the new law, what's required, and then we can talk about some of the issues that are out there as to interpretation. And really, do you want your client to say they are a tenant? Because there's some risk in that. And one of the obvious risks is that the purchaser can then take them to court for not paying rent, and they can end up getting a judgment against them, compared to the old system where it was extremely rare in the ejectment action for the occupant to be named, and therefore they really didn't run the risk of having an adverse judgment entered against them, either generally for just possession, which still could hurt them. But David, why don't you begin with the new law?
For those of you who, some of you know me, for those of you who don't, I practiced in Philadelphia for many years. I was a legal services attorney for many years. And for the past several years, I've worked with the National Housing Law Project in the Washington, D.C. office. And many of you are members of the Housing Justice Network, which is a self-identified group of 700 advocates across the country who do housing justice work. So I have some background in housing and landlord-tenant, and when I was at Legal Services, that was my focus, was federal housing work. So this is a law now, which was originally introduced in '07, and then introduced and went to committee in both houses of Congress in '08, was ensconced partially in the TARP bill, where there was federal money involved in the conversion of the title conversion of the property, and in ARA, the recovery bill from February, which said that whenever federal money was involved, particularly with the neighborhood stabilization program, which many of you may have some familiarity with, they were governed by certain provisions here. And then on May 20th, the president signed this bill, which governs every residential property in the country, 48 states, DC and Puerto Rico and probably Guam. The law is self-executing. There will be no regulations, although we are going to talk a little bit about the notices and bulletins and advisories that have been put out by various federal agencies and departments. You have a copy of this law in the handout material, and several other documents in your handouts, and then there's a list of about a dozen pieces of information which are on the disc and which appear on the National Housing Law Project's website, nhlp.org. They also appear on the National Low Income Housing Coalition's website and on the National Law Center for Homelessness and Poverty. These are the three groups which from Washington have been working to educate people around the country on this bill. So, not bill, excuse me, it's now the law. The law says that in the event of a foreclosure on residential property, the successor in interest at foreclosure takes subject to the lease and may not evict the occupant tenant, if they're a bona fide tenant, on short of 90 days notice. And if the lease term has a balance of more than 90 days on it at the date the title transfers, then the successor in interest must allow the tenant to live out that lease and still provide 90 days notice. So if the lease runs through, so if foreclosure, if title transfers today, and the lease runs till December 31, 2009, then sometime before October 1, the successor can give 90 days notice to the occupant to be gone on December 31st, and thereafter can proceed with eviction. The exception is that if the successor in interest wishes to occupy the property as a primary residence, so that automatically knocks out banks and other lenders and investors and a whole range of people who tend to be the acquirers at sheriff's sale. But if the successor wishes to occupy as primary residence, then notwithstanding the length of any lease term balance, they can give the occupant 90 days notice. So everybody gets 90 days notice. Now, there are some nuances in the law which probably exceed the time limits we have here today. And George and I will talk about some of those. If we were all king of the world, the language might be a little different, but we have what we have. Because the first sentence says, in the case of any foreclosure on a federally related mortgage loan or on any dwelling or residential real property after the date of enactment of this title, any immediate successor in interest in such property pursuant to the foreclosure shall assume such interest subject to. And then it says 90 days notice and or the lease, whichever is longer. So why the phrase federally related mortgage loan is in there just before or any dwelling or residential real property has raised amazing discussions among the advocates across the country and raised issues which fade into history as we get further and further away from the date of enactment. And the question was, if a foreclosure occurs before May 20th, but the notice to vacate does not issue until after May 20th, then in most cases, the law is still governed because we argue that it governs the date of the notice. And only the successor in interest can give such notice. And therefore, the fact that title changed hands before May 20th is of no import for federally related mortgages or, under the next section, which I'll get to, Section 8 voucher participant properties.
You know, one of the, and
Yeah.
Dave and I were talking about on the train on the way up, as lawyers, and we always try to look into legislation, and we see there's some different language, well, why was it written differently, and come up with reasons. And over the years, I've become convinced that a lot of this is simply sloppy drafting. They really didn't intend any of this, but the reality is we have what we have, and let's try to use it the best we can.
Right.
But we often think that, and this bill went through various different changes, and some staffer probably at the very last minute was told, get something together, because this bill came through at the end very quickly, and they took probably a bunch of different things, put it together, and this is what we have.
So I'm just going to say to people, if you become involved in issues around this case, and there are questions of interpretation and statutory construction, please give me a call, please email me. There are memos and discussions of all these issues within the Housing Justice Network, and memorandum of law have been created, and so I think we can probably be pretty helpful on individual basis, on individual cases. In general, I'll just say that federally related mortgage is anything covered by RESPA. So it's a 1 to 4 unit property which is subject to a mortgage by any commercial lender and any private lender who lends over $100,000 a year, and anyway, it's a long list, but it's in the bill. It's 12 USC 2602. So that's the first, okay. Now that's section 702. The other provision in 702 is that the tenant must be what the law calls a bona fide tenant. And it defines bona fide, and not in a positive way, but it says if you fit one of the following categories, you're not a bona fide tenant. So the first category is you are the mortgagor or the parent, child, or spouse of a mortgagor. So 3 days after the law is passed, I get a call from the sister of a mortgagor. Well, she's not excluded, okay? The statute is very clear. Remember that phrase from law school, inclusio, unios, ex, whatever it is, right? If you make a list and it's not on the list, It's not there. Okay. The second category is that it must be an arm's length transaction, whatever that means, right? Property 101, what is an arm's length transaction?
Well, that's, the sister may be excluded under that.
Well, okay, but I told her, no, see, anyway, we won't get into that. Okay, we're not going to do that. Okay, and the tenant must be paying not substantially below fair market rent unless there's a subsidy involved. So, a Section 8 tenant that's paying $25 a month is covered, even though they are paying substantially below fair market because it's in coordination with a subsidy. So those are really the exclusions. So it covers virtually every residence in the country. The next operative section, Section 703, governs Section 8 vouchers. It does not govern project-based Section 8, which are covered by a whole other area of law beyond the scope of this discussion. But project-based tenants are covered by Section 702, the general section. 703 is in the Act because you all remember that 42 U.S.C. 1437 F07 defines, I know, that's what I do for a living, I'm sorry. It defines, it gives certain clauses which must be part of every Section 8 voucher participant's lease, right? Certain clauses about what is good cause for eviction and what are the conditions which govern the parties. And so because that's statutory, if you're going to modify it in this way, you have to modify that statute. So if you read the law carefully, you'll see that Section 702 provides the changes in the law necessary to make this operable for Section 8 voucher holders. And it says specifically that both the lease, because 702 only covers the lease, but both the lease and the HAP, the Housing Assistance Payments Contract, which the owner has to have with the housing authority or whatever other government entity is administering the Section 8 vouchers, that contract also survives foreclosure. Okay? So it's now statutory. There were a few other nuances, but like I said, if you run into them, call me. So everyone across the country is entitled to at least 90 days notice. And the vast majority of people around the country are not getting 90 days notice, even now. And we're 3 months past the adoption of the signing of this bill.
One other thing, and it will come up maybe later, but it's important to point out that in Section 702, it talks about the rights of the tenant as of the date of such notice of foreclosure, which we think is an important issue. We think it's very clear what that means. That notice of foreclosure means once the purchaser at sheriff's sale has acquired the property, i.e. gotten the deed from the sheriff, the foreclosure is then completed. There are banks and lending institutions out there are making the argument that no, you have to be a tenant at the time that either foreclosure commenced, that somehow there is something in the process that started the foreclosure process. If you became a tenant after that, you are not, quote, a tenant for purposes of this law. And that obviously becomes important. As time goes on, it won't be important, but there are still now situations where the tenant may have moved in after the foreclosure was initiated. All the advocates are abundantly clear that, quote, notice of foreclosure means that the foreclosure has been completed.
Right, and our position is that foreclosure means transfer of title. There is an instant before foreclosure and an instant after foreclosure, and the 3 months or 4 months or 6 months that it takes to process this is not an issue.
Yeah.
But you'll see if you read it that where it says such notice of foreclosure, it's the first time it uses the phrase notice of foreclosure. Well, what does such mean? No? Okay.
Yeah. I mean, Pennsylvania has the notice of intent to foreclose, and our argument is that that's different. That is not notice of foreclosure. That's notice of intent to foreclose,
Okay.
which is the beginning of the foreclosure process.
So, given that analysis, when it talks about notice to vacate, the only entity capable of giving a notice to vacate is the successor in interest, right? not the bank when it decides that the mortgagor is 3 months in arrears. So these are the kind of hard lines that we need to draw on the implementation of this statute to keep the lending community at bay, because I get calls, and the other nonprofits who are working on this nationally get calls every day from across the country from people who have awakened one morning to find the sheriff at the door. And maybe they got a notice 3 days before from a law firm that specializes in mortgage foreclosures and subsequent evictions, which says, get out now. Now, Armageddon is coming. We will take you to court. If you don't, so, okay. So, one of the things that's happened since May 20th that's important, and you'll see that material, a couple of the things were in the handouts, and some more are on the disc. There's a bunch of material on a disc, which I'll get to later. But one of the things that's happened is we have been working with all of the federal regulatory entities which govern these processes. We have the advocates in Washington. We have had meetings with the Office of Control of the Currency, with the Federal Housing Finance Agency, with the Federal Reserve banks, with Fannie Mae, with Freddie Mac, the whole laundry list, and they all get it. The Office of Controller of the Currency, which many people have probably never heard of, manages and operates and regulates the 5,000 banks in the country that are federally chartered. And they have issued, and you'll see it as one of the handouts, there's an OCC complaint form, and on your disc, there's an OCC notice from August 13, which tells the banks, this is now on the regulatory investigation checklist. If we see you're messing up, we're going to tell you. Now, do we think that they're going to come down hard on the banks? Right, I'm not holding my breath. But you know it's out there, and it's a potential tool like everything else. The Federal Reserve has issued notices. They're not in the materials because I think it came out too late, but they are on the website, the National Housing Law Project website. HUD has issued a guidance at 74 Federal Register 30106. It appeared on June 24. 74 CFR 30106. There's a letter in your materials, a New England HUD advisory letter, which is in fact a little more tenant-friendly than the Federal Register notice, which is also in the material, and which a lawyer at HUD told me they were really sad that it had been issued, but it's out there. It's because it addresses a couple of these nuances about the law. So let's see, we're down to success rate. Oh yeah, a question. Fannie Mae and Freddie Mac have had since November and January or March respectively what they call REO rental policies. It means real estate owned by a financial entity, REO, where they have determined that in compliance, in deference to Section 109 of TARP, they will allow tenants to remain in the property on a month-to-month lease, subject to sale whenever they can market it, and subject to invasion by marketing real estate agents. So Fannie Mae and Freddie Mac have effectively three policies. You can exercise your rights under the Protecting Tenants of Foreclosure Act. You can take our month-to-month lease and let us sell the property out from under you, or we can give you relocation assistance. And as George said, relocation assistance is an issue. I got a call from somebody who said, the Fannie Mae people were here. No, they didn't give me the notice that they were supposed to give me, but I have a general idea of what's supposed to be going on. And they asked me to get an estimate for moving. The estimate for moving was $1,500. They offered me $1,500. However, as George has clearly pointed out, we all know that you can't move for the cost of the truck. You need 3 months' rent in the bank. So I raised that with Fannie Mae's lawyers, and one of them said he would call this woman in question and see if they could resolve it. But I find it hard to believe that that's going to happen. And there are real estate professionals and lawyers across the country who hold it as a point of honor that they can get anybody out of anything in 2 days. You know? And the letters we see from across the country are vicious, just vicious. If I got one, I'd be looking to move to Canada. So if you go to Fannie Mae's website, they have this little sheet, and we're in constant discussion with them because their deference to this law says, option 1, continue renting this property. First bullet. If you are renting this property, you might have the right to continue living in the property under your existing lease. Many tenancies are protected by the Protecting Tenants of Foreclosure Act or other applicable law. Next bullet. You may also be eligible to enter into a new lease with Fannie Mae. After that bullet, there's 3 more inches of text. Okay? And then below is relocation assistance. And I constantly argue with the lawyers, at least you should say one more line under the Protecting Tenants law, which says you have at least 90 days to leave. You must receive at least 90 days notice. So they're skirting on the edge, and they're trying to avoid it. And the people from Washington keep saying, oh no, we're doing it right, we're doing it right. But in the trenches, we know that that's not happening.
Okay, does that only apply to Fannie Mae and Freddie Mac owned properties?
Yes, yes.
And is there a time limit by when a tenant must accept a relocation?
Well, there are some changes in here which were the result of advocates' discussions with Fannie Mae. And there is a clause which we suggested, which says failure to notify Fannie Mae with this is theirs. They said failure to notify Fannie Mae within 3 days will result in our pursuing eviction. We got the clause now to say failure to notify Fannie Mae within 10 days will not result in a waiver of any of your rights. Now, what does that mean to your average client? Okay, so, and that's not at all clear with most realtors or eviction lawyers' notices. They really say, give us your family history. To prove you are a bona fide tenant, we want to see rent receipts, we want to see security deposit receipts, we want to see mail that shows you're paying the utility bills, right? Okay, none of that is required under the law. In theory, it's a self-activating law, self-implementing. The bank should have to prove that your client is not a bona fide tenant, because otherwise, they're a bona fide tenant in my mind. Other issues which arise are whether the law says that the successor in interest is bound by the lease. It doesn't say the occupant is bound by the lease. Can your tenant walk away if the bank says, no, you owe us September's rent, right? Okay, if the tenant can't show a rent receipt for August, can the bank say, we are the successor to the lease, right? We stand in the shoes of the defaulted mortgagor. Where is July, August, and September's rent? You don't have a receipt. Well, I've had plenty of clients over the years who paid the rent because somebody knocked on their door the first Saturday of every month and took cash. So those kind of nuances are, they're a problem in terms of fact. But the bottom line is that after years and years of being able to run roughshod over occupants, a lot of people in the real estate business can't get it into their heads that this is a federal law. There's this argument in Texas. There's a state statute in Texas which says that upon foreclosure, a transfer of title, every lease turns into a tenancy at will. Therefore, the lawyers in Texas are arguing, fine, we have a lease with you under a tenancy at will, goodbye. Right? Leave tomorrow, because under state law, the day after foreclosure, you don't have anything but a tenancy at will. Well, that's patently absurd, because the statute says it's absurd. They take subject to the lease which predated the transfer of title. So these are all issues which, when you first read the law, it makes perfect sense. And then you start seeing the ways people torture it, and you have to go back and reread it. Okay.
Yeah, another question is the successor in interest. The law particularly talks about the successor in interest after the sheriff's sale. What happens if the bank flips it 3 days later and someone else comes in? Are they bound? Do they have to give the 90-day notice? Our argument is yes, even though it uses the word successor in interest, the person who takes that, purchases the property, takes that property subject to the lease, and that lease is subject to the law, therefore they're bound by the law.
Right.
It's unfortunate that the word successor interest is there, but I think there are ways of getting around that.
At a webinar we had yesterday, the Freddie Mac lawyer said that the second successor is not bound by the law. Now, there are two ways to look at that. One is that flies in the face of the intent of the federal statute, but two, in virtually every state, as we all learned in Property 101, it's a first-in-time rule. So as George just said, I'm just trying to say it again because it's a concept we talked about a bunch. If the lease burdens the property on the date the bank sells it to the prospective homeowner, the lease burdens the homeowner's title. Make sense? So the successor to the successor is bound because it's now a cloud on the title.
Let me talk about some practical considerations, because our office is getting a fair number of tenants who come in with this, and the question is, and hopefully some of you have thought about it, how do you advise tenants, what should they be doing? The typical scenario we see is you have a tenant in a property where the landlord's being foreclosed. They may come in before, they may come in after the deed is passed. Generally, sometimes they come in before. If they come in before, often the property is not being repaired. The landlord's being foreclosed, he's not paying his mortgage, there's a substantial likelihood they're not making repairs. What we generally tell tenants is, you're still obligated to pay the rent until sheriff's sale takes place, but it doesn't make a whole lot of sense to be paying this landlord because you're probably going to have to move. What you need to do is to set this aside, because there is a possibility that in fact the landlord will work something out. A lot of these foreclosure cases, the landlord does work things out and they will continue and you're going to owe the rent. So if you want to possibly stay there, you certainly need to put the money and keep it aside. Assuming there is a foreclosure and assuming the title does pass from the sheriff to this new purchaser, what should we be advising tenants? And I think the tenant has to understand that if what they want to continue as tenants, if they're on a month-to-month lease, if once they say, I am a tenant and I have a right to a 90-day notice, well, what's that do? What that does is it obligates them to begin paying rent, number one. And if they don't pay rent, the purchaser can go to court, landlord-tenant court in Pennsylvania, file an action, or district justice, and get a judgment against them for rent that is accrued post-sheriff's sale. There is also an argument, which we don't, hopefully is not correct, that possibly the purchaser, because the lease has continued, can ask for rent that was owed prior to the sheriff's sale. In fact, in some cases, they're asking for rent receipts and asking for that money. So the question is, does the tenant want to say, I am a tenant, I want to continue living there? Obviously, if the tenant has a year's lease and that lease is up 9 or 10 months after the sheriff's sale, you're going to make every argument you can, and if necessary, file the appropriate legal papers to keep that tenant in the property, assuming the tenant wants to stay. Many tenants don't want to stay simply because the place is in poor condition. They need time to get to another place. So the thing is to try to negotiate, if that's what they want to do, to give them time. Yes?
When you say you're telling the tenants to keep paying, are you advising them to put money in an escrow?
Not a formal escrow, just keep
But
it.
keep it aside so they can
Keep it aside, because there's a possibility that, in fact, the landlord could file a bankruptcy, the landlord could work something out with the bank, and they can continue being the landlord. And if they want to stay there, at some point, they need to pay the rent or they're going to be taken to court. Now, they may have defenses, to the legal action in court, but it's something we need to tell them. The fact that a foreclosure has been filed legally is not a reason to stop paying rent.
Okay, now,
Yes.
okay, go ahead. Then I have a-
The concern you have is that if they're not a landlord-tenant, if you don't consider them to be landlord-tenants, then they go through the ejection process or another process I can't really mention, but, then they wouldn't necessarily owe rent, and so you don't get stuck in the.
Well, you don't really, I'm not sure the new purchaser has that choice. I suspect you're gonna continue to see purchasers, we have seen it, filing ejectment actions against occupant. That could give them 90 days, and if the tenant doesn't want to pay rent, if they want to leave, it gives them 90 days, they're not going to get a judgment against them, and they can go on their way.
Yeah, except for the fact that I think that I think you have, that the owner would have an argument that the quantum merit argument for, fair value while you're living there, which they get anyway. I've even seen, in the normal process, plaintiffs sue for that, after foreclosure.
Okay, so,
That's one
right.
issue. And
Well,
secondly,
for home-
they can also sue in trespass, which could be, they could file trespass charges if you say that there's no lease, and that could be a problem too.
Well, but how does that, see, I'm not that conversant with this nuance of Pennsylvania law, but how's that work within the ejectment construct?
I don't think they can file
If
trespass.
there is no landlord-tenant relationship, then what legal right does the occupant have to be?
Well, they're a possessor with a claim of right and they must be ejected.
That's right, they must be ejected. At least in Philadelphia, we don't run into that problem
Okay, so-
of tenants being trespass actions filed against
I've never
them.
seen it, but I've always thought it could work.
Well, don't speak too loud. Maybe somebody's-
This raises another piece of the law, which is appropriate at this point, which says that the provisions related to foreclosure, shall not affect any state or local law that
Yeah.
provides longer time periods or other additional protections for tenants. So, more onerous state laws are superseded by this statute. But laws which protect tenants, giving them longer periods to vacate or other protections, are not superseded. So in Philadelphia, they have a thing called the Fair Housing Commission, and it's a mechanism for enforcing the right to quiet title and habitability, warranty of habitability. So a tenant who knows that the landlord is going to suffer foreclosure within some couple of months, they have last month's rent and they have security deposit on deposit. And if the conditions of the property are deteriorating, you should consider what remedies exist within your local jurisdiction to allow a tenant to escrow rent against the conditions of the property under warranty of habitability claims and other kinds of claims. So there are those kind of benefits. And then if the tenant has the money in escrow, they can say, let the court sort it out, but you can't evict me for non-payment of rent. And that means that I suggest that if you have clients whose property are subject to warranty of habitability claims, and they know there's a foreclosure in process, they should send a letter to their landlord, certified mail, return receipt requested, et cetera, as soon as possible, saying, I've been after you for months to fix the toilet, right? Or to clean that black mold off my child's bedroom ceiling. I am now escrowing my rent in response to that, because I believe I'm getting less than I'm paying for. And whatever your local, however you deal with that in your county or in your jurisdiction, but it's just a construct, because the rent will become an issue.
Yeah, Pennsylvania, of course, has the Rent Withholding Act, which, if someone is escrowing their rent, prohibits an eviction, and that would clearly apply to a purchaser at a sheriff's sale if the place was unfit. They clearly could not evict, at least during this 6-month period of time. That is a very important provision, because what we intend to do in Philadelphia in the appropriate cases is to file claims with our Fair Housing Commission and make the argument that, notwithstanding the federal law, there is this provision that say local laws which provide greater protections also apply, and if there are housing code violations in a property, a tenant in Philadelphia cannot be evicted. So this does give the avenue to raise those kinds of claims. Now, the Fair Housing Ordinance is somewhat unique to Philadelphia, but I suspect there are other creative ways attorneys have in saying if the property is in poor condition, a tenant cannot be evicted.
Yes.
Is there anything there that deals in the federal act that deals with self-help evictions and things like discontinuing water service to a property? I mean, that's something, if you have, that's something that there's some protection in the state law for, if the landlord is responsible for the water service.
Well, there's no, the only thing the federal law says is that the successor takes subject to the lease. So any state remedies a tenant may have are applicable within, unless the tenant has received a 90-day notice, and until that 90-day notice expires, a tenant would have
The same rights.
right, a claim to go into court, whatever your equity courts allow, and there's protection there. But we all know that the access to the courts for most of the people affected by this are limited. The National Low Income Housing Coalition did a study 2 years ago when we just saw this foreclosure crisis coming over the mountain that concluded that 40% of all property, of all residential property subject to mortgages in the country are occupied by tenants. So this affects a dramatic number of tenants.
It seems to me that might affect whether or not you want to assert your rights as a tenant or as an occupant, because there are way more state law protections for tenants
Yes.
than there are for occupants. So that might be one of the issues that you'd be considering if you were contemplating whether you wanted to be a tenant or simply
Yes.
be an occupant.
The statute doesn't say that the tenant is bound by the lease. It says the successor is bound to be the landlord, but, you know, a lease is a contract, so you're gonna have to pick one or the other, I think, in reality.
Let me shift gears a little bit to the Section 8 issues, because as David said, the law requires the purchaser of the sale not only to give the same notices, they have to give to a private tenant. This is on a Section 8, but the contract, the housing assistance payment contract between the former landlord and the housing authority continues. The problem, of course, is we get Wells Fargo purchasing one of these properties at sheriff's sale that has a Section 8 lease in it, and they're going to just thumb their nose at the housing authority when the housing authority asks them for information, regarding them, because they need to put this information into the database because they now have assumed the contract, and they refuse to do anything, and the housing authority says, well, we're going to terminate the Section 8 contract. And we thought this through, and I think what's going to happen is you're going to have to bring an action against Wells Fargo or whoever the purchaser is to force them to comply with whatever requirements are imposed under the Section 8 housing assistance payment contract. Otherwise, the new law becomes a nullity if the purchaser can just refuse to cooperate and then be terminated from the program. And that is clearly an issue, and I think we have to be very aggressive in forcing purchasers to comply with whatever requirements are under the, because now it's sort of interesting, they have now been forced into becoming a participant in the Section 8 program, which is probably the last thing they want to do.
Yeah.
Although conceptually, if they don't care really about participating, they can still agree to just take
The tenant share.
minimal rent, the subsidy.
Right. The little glitch in that is that there's a regulation in 24 CFR that says that if HAP contracts have been suspended for any reason for 6 months,
Yeah.
the contract automatically terminates. Now, you're not going to get a lot of situations where you're 6 months into this circumstance, but understand that's looming out there. And there was a version of this bill which there were various versions of this bill, as George said, and you wonder why they didn't get enacted. But in any event, this is the version which was on somebody's desk when it was introduced. But there was a version which specifically said if the successor in interest refuses to take the HAP money, that the housing authority can use it to pay utilities for the tenant if they're the landlord's responsibility, and can use it for relocation. You can't make repairs because the liability concept of the housing authority hiring a contractor to fix somebody else's plumbing, becomes an issue. But it did allow them to pay external vendors for utilities. But it didn't make it this far in this version. So here we are.
Another issue which David touched on is, is the tenant bound by this? Are they required to become a tenant of the purchaser of the sheriff's sale? Say they just want to walk away. I mean, if you read the law, it's a little unclear on that, because it basically says the lease continues, as a practical matter, after the sheriff's sale. And is the obligation only imposed on the purchaser? I mean, if you're living in a property and your landlord sells the property to somebody else with your lease, you're bound by that lease to the new purchaser. The question here is the tenant bound to become a tenant? Now, I think as a practical matter, most of these purchasers, the last thing they want to do is continue the tenancy, so they're willing to have the tenant walk away if in fact that's what they want to do. But there's a lot of issues out there.
Another issue which has come up in several states are that the lawyers who do the evictions have gotten together with the banks and come up with this scheme which says, we are a lending institution, we're not allowed to hold property. We lend money, we are not realtors. The truth is that the OCC, which regulates the vast majority of banks you're going to deal with, their regulations allow these banks to hold a piece of real estate for up to 5 years, and with approval upon application to the OCC, they can hold it for an additional 5 years. I've seen the letters where the banks and their lawyers are saying this law is in violation of the federal regulatory structure within which we work, and it's just not true. And Barry Whitus from the OCC, who appeared on our webinar yesterday, said that exact thing. Okay, he was asked a specific question, and he gave a specific answer. So that's not a problem. The OCC has a computerized complaint form people can fill out and send in. Like I said, we don't know what they're doing with them, but if you do, send me a copy, because we're trying to get some sense of what's going in to the national. As I said originally, the Housing Justice Network is engaged in lots of discussions about this. If you're into housing and you want to join that network, you email our office in Oakland, California, and they'll set you up. The collection of nonprofits which are working on this, we've created our own email address, which is PTFA, Protecting Tenants at Foreclosure Act, PTFA Matters at gmail.org, gmail.com, sorry. So you can send in questions to that,
Yeah, I would also encourage, I assume most people in the room here are on either the state housing listserv or the consumer housing listserv, or both, and I would strongly encourage people, which they do all the time, to pose questions on there so we can get a statewide communication, because I think every state law is different, and how this law impacts on each state is different, and I think, Pennsylvania is clearly different than other states. Yes, honey.
I'm sorry, could I say one more thing in that regard? Judges, landlord-tenant judges, probably have never read this law. Right? If there's anything any of you can do in your jurisdictions, or anybody is engaged with the state judiciary, if there's any way that this could filter down in some coherent message to the judges who handle foreclosures and evictions, that would be a wonderful thing.
Yeah.
I have a law student who's trying to figure out how to do that in 52 jurisdictions.
We've talked to just local judges here in both the common pleas level and the municipal court level about this. Our municipal court has, I don't know what they call it, a conference about every 6 months, which we're going to do a presentation, hopefully, on the new law. But it is very important to inform judges at both levels, common pleas and municipal court, or your district justices, about the new law. But
Yes, honey.
Is there any argument that this law applies to property acquired through tax sales?
no. Well, somebody raised.
Up on the list, sir.
That came up
on a list,
yeah,
sir.
It came up, and I reread it, and it's interesting.
Okay.
It talks about, in the case of any foreclosure on a federally related mortgage, or on any dwelling or any residential mortgage. So it's, a technical reading of the law, conceivably you can make the argument. I'm just not sure how far
Yeah.
you're going to go.
you'll see in the, where is it? Yeah, on your disc, there's a congressional record that Senators Dodd and Kerry entered on August 6th in retrospectively to try and say what they meant. Kerry introduced it and Dodd was the chair of the committee, all right? And they, there is scant legislative history because
There's none.
this is title, right. It was originally Senate 986 in the 111th Congress. If those of you who can search Thomas's Library of Congress site, you can see some of that. There's, but it was Title VII of a bill primarily focused on mortgagors and mortgagees, and trying to protect people from foreclosure. So, and it was introduced very late, and as you can imagine, it's our. The only thing we can imagine is that the other side never even saw it coming because there was no fight and there was no, and there's really not much legislative history. There's a couple of paragraphs here and there. If you look at the material that's in your materials on the disc, it indicates that it really has to do with what we all think about when we think of mortgage foreclosures, and I have to say that I think I gave that writer scant encouragement on the question of tax sales. But I'm always one for making the argument because, you know, if you don't ask, you don't get. And maybe the other side, I mean, how many...
And you may get a sympathetic judge.
Right. You know, a lot of times what the judge wants is a reason to do
That's
what you
exactly
convinced him she ought to do. So, and on the other hand, how many eviction lawyers or banks lawyers are going to have read the congressional history on this, if they even know how to find it? So, you know, be as aggressive as you can possibly be.
Yeah, if you have questions, as Dave said, he'd be glad to try to answer them. I'd be glad to try to answer them too at cgould@clsphila.org. And also put the questions on both, if you're a member of HJN, that's a great way to get answers to stuff, and put it on the statewide housing listserv. Other questions from folks? I think
I think we're about there.
Yeah.